I'm Adine Mitrani, a senior associate in the Tech Transactions Group in New York, and I'm joined by my stellar co-host and mentor, Toney Jacobson. He is a partner in the IP group in Mountain View.
Hi, I'm Toney Jacobson, a partner in the IP group at Fenwick's Mountain View office. Today we are so excited to be joined by Andrew Whitehead, Associate General Counsel at Genentech, a pioneering biotech company. Andrew studied physics at MIT and law at George Washington University. Andrew and I were actually summer associates together in Big Law a long time ago, where he became one of the first attorneys anywhere to specialize in the intersection of life sciences and AI. In 2019, Andrew went in-house to Genentech as their first software IP counsel. Today, he leads Genentech's discovery and computational sciences IP team and has been instrumental in shaping the company's approach to AI, data, and IP strategy. Andrew, welcome. Thank you for joining us today.
Thank you for having me.
Bit of an icebreaker. Let me ask, is there a good example of how AI has improved your day-to-day life, or an anecdote that you can share that was unexpected 5 years ago even?
Oh, geez, good question. I feel like day to day, the thing I see most is my son using ChatGPT to think about how to structure the answers to his homework. And the conversation is very much around the lines of making sure that he's not using it too extensively in the work that he does, which is something that I don't think I thought about when I became the parent of kids. So that's definitely changed my day-to-day life, at least indirectly, if not directly.
Yeah, that's a great example. I also, my anecdote is related to kids. I used it actually to generate the scavenger hunt clues for my kids' Christmas morning stocking hunt. And my dad would be rolling his eyes if he realized that I wasn't doing it manually like he did. But in the end, I think it creates the same magic, and they don't know.
Yeah, I agree.
My example also relates to kids, and I do think it creates a bit of magic. So I use it as story time for my 3.5-year-old daughter. So we use the AI voice, and it generates a whole story where she wants to be, what she wants to do, what comes next, and it makes for a great bedtime, and I could be doing other things while she listens. So moving away from kids, curious, how do you view the value of AI in the life sciences industry, and how this affects your view compared to, say, 5 years ago?
Well, thank you for the question. 5 years ago, I don't know that it's changed all that much. As my intro indicated, I've been interested in the intersection of computation, but AI specifically, and the life sciences for maybe the last 10 or 12 years. And so I was kind of thinking about this in the era where we didn't really have LLMs. It was mostly convolutional neural nets and things that the major tech companies were starting to put out. And so for me, it was for a while the way to get to partnership, and then it became sort of something that I was fundamentally interested in and wanted to see impact in the real world. And that was the reason to go in-house. And that's what I ended up working on. And so the last 5 years, like for me, it's been sort of a 10 or 12-year journey. And so at the 5-year mark, not really anything to me has changed. And even now, like with LLMs being sort of in the zeitgeist in a major way, I don't really view it all that differently. And I think that's maybe good and bad. Like, it's been interesting to see how much it has changed for everyone else, when from my point of view, it's a particular type of tool. It's within a broad sort of like genus of tools, but it's sort of the same as it's always been. It's input, it's output, and it's making predictions on things in the real world. And so, yeah, I think I'm mostly struck by how everybody else is observing these changes and talking about how they're using it and these things they can do. And I'm sort of like, dumbfounded a little bit with how creative everybody is. So, yeah.
Yeah, that's a really interesting take, because Fenwick also has been doing AI, machine learning since the very early days. But in the last 5 years, we have seen an explosion of new clients coming up with very different technology, trying to disrupt the industry in various different ways. But you're right, 5 years ago, similar technology, but just we've seen an explosion with those clients.
Yeah, and from my point of view, being an attorney who wants to interact with peers who work in the space, one of the things I've seen change is that our peer companies at other biopharma now have roles within their IP teams or within their broader legal teams for roles that look like mine. And so I now have peers at most major other biopharma who I can talk to and do talk to about what are they seeing, what's going on, how is computation affecting how their company invests money, or what they're thinking about for IP. So that's something that I didn't really see or wasn't around 5 years ago that I definitely see today, and that's kind of exciting.
I've known you for a number of years now, and I'm impressed by how you've kind of transcended your role and your position beyond IP. But taking a step back to your patent roots, let me ask you this. This is something I struggle with on a day-to-day basis. For years, we've heard that AI and software patents have hit a wall on abstract idea and eligibility type rejections. From your perspective, how hard is it today to get meaningful patent protection for AI-related inventions in life sciences? What's actually changed, say, over the last 3-5 years, and what hasn't?
Okay, so is it hard to get meaningful patent protection? I think in some ways, yes. I guess this is such a lawyer answer. Like, it depends what you mean by get meaningful patent protection, because it depends whether you're talking about getting the patent issued by the patent office in the US, in other jurisdictions. Are you talking about, is it going to stand up in court? Is it going to stand up in appeals court, right? There's many thresholds, and so I feel like the standard's different for each of them. To go into specifics, I guess, on some level, I don't feel like things have really changed in the courts, right? What we're seeing from the federal circuit. And from my point of view, in a biopharma, we have to pay attention to both the sort of Alice and Bilski line of cases that relate to tech, and we also have to pay attention to the Mayo and Myriad line of cases which relate to bio. And so trying to thread the needle between all that case law, and then also as a, as a company thinking about what our stance is on eligibility in general, I think we've seen things calcify in terms of what the federal circuit does in some sense. And we haven't seen a lot of meaningful movement from Congress, though there have been initiatives to change eligibility law every couple of years since I was in private practice. So not a lot there. I mean, we've certainly seen a lot of motion from Director Vidal. We've seen motion from Director Squires around AI, trying to change the eligibility standard or make it clearer for examiners as to what the standard is, to make things be able to move faster via declarations is now the latest thing. So we've seen some movement there, but until we start to see lots of litigation around AI type cases, and particularly have them be decided in courts where that then pushes the standard, if we don't see anything on the legislation side, I think it's hard to say that anything has meaningfully changed. So yeah, like you can get those patents probably, and it depends on the subject matter. Maybe you have to add elements, but the long tail of this is like a 10 to 15 year or 20 year ballgame. In the grand scheme of things, we really haven't seen a lot of meaningful change, even though we've seen change at the patent office. And so what I'm really waiting for is whether or not we're going to see change in what the courts do as a result of these cases.
So from a tech transactions perspective, I have been following what the USPTO has been doing, and I saw that they recently loosened restrictions on AI-assisted inventions, essentially saying that humans can use AI tools without losing their status as an inventor. How big of a deal is that in your practice?
So thank you for the question. So there's been a lot of motion on this topic from the USPTO in the last few years. So the previous director of the Patent Office, Kathy Vidal, put out a fairly extensive guidance that walked through with different areas of technology how when you involve AI, how that changes whether or not there would be a human inventor, and therefore whether you can get a patent. So they gave out a couple of examples for designing drugs using AI, including AI. And they walked through some scenarios, and in some scenarios there was a human inventor, and so you can get your patent claim, and in others maybe there wasn't. And so that's really useful if you are a practitioner who's an IP practitioner, or if you're a small company who's looking for guidance as to how to protect their IP strategy. You would be able to look at that and say, do I have an invention or not? And so that was really useful. So what I think you're referring to most recently is the guidance from Director Squires, rescinding the previous guidance, putting in new guidance that was more lax, essentially saying that in more situations, there's going to be a human inventor and you're going to be able to protect your invention. I think that's a clear sort of signal that the USPTO and the government in general are interested in U.S. companies getting patents on AI, and I think that's part and parcel with their broader strategy as administration in promoting AI advancement by the U.S. in relation to other countries. So directionally, that makes total sense. Practically, does that meaningfully change things for practitioners or startups as to what kind of patents they get? Probably not. It's probably more guidance is always helpful, but I'm not sure it really moves the needle because the other guidance was pretty good as it was. But I don't know, more interaction from the USPTO is not bad. So happy to have it.
You work for a major biopharma on the cutting edge of AI partnership. From your perspective, what makes a good AI partnership, and what are some red flags that might kill a deal quickly?
So AI and deals, and what would kill a deal fast? So I think that alignment of objectives and expectations is really important. That's maybe generic advice, but in the context of biopharma or in any industry really, there tend to be certain standards around the kinds of deals that people sign and the terms that are in those deals and what the expectations are. And so a lot is baked in where when two parties come to the table, for example, in a biopharma context to in-license a molecule, there's a lot of sort of set expectations. There's terms that are air quotes like market. And so everybody coming to the table, sort of certain conversations don't need to be had because everybody knows what we're talking about. AI introduces sort of a new framework for how to think about a deal. And so when people don't have knowledge on one side of the table or another, they haven't dealt with terms like AI models or embeddings or training or weights or what have you, you have to handle that. And so one of the things I've worked on is upskilling my organization about those topics alongside many other people. And then I've seen personally that the industry has shifted a little bit as, whereas maybe 5 or 7 years ago, there was less knowledge on this topic from counterparties that I was working with. That knowledge has grown over time as everybody's been inundated with AI in their daily lives and sort of in their tech and everything else. So,
yeah, completely agree. I would even say from 2 years ago, most of the counterparts definitely know about AI. They know what to look for. Data is one of the most hotly negotiated provisions, and we see a lot of biopharmas being super protective. And so when we're representing the startup companies, we just have to navigate that and see where there could be a value exchange. Another thing that I'm seeing also is the interplay between data and IP. So if there's an improvement to a model based on data, who would own that at IP? And that's also another discussion. So very interesting for the IP lawyers in the room when we're doing these deals.
I totally agree. I think it really gets into the nitty gritty of a deal. And what I find personally is that very often in the context of a specific transaction, two parties can say, well, we're going to do a certain project and we're going to do certain research, right? We're going to generate data or train a model or, do wet lab experimentation on the results that come out of the model. And everybody's aligned with, payment structures, right? Who's going to get what coming out of that discovery, right? Maybe it's therapeutic, biobucks of some kind. Maybe there's a molecule, maybe there's an in-license or an out-license, whatever it is. Where it gets really hard is downstream of that. These sort of long tail output. Who gets to use the model for other stuff? Who gets to use the data for other stuff, right? And it depends who you are, right? If you're that AI startup that is actually relying on bespoke or proprietary data to fuel an engine, to train your models, to build your company, to sell it to somebody else, that's going to be in tension if the other party wants to do the same thing with their data. And they're just using you as a service provider for some smaller bit that they need. So it gets often the main part of the deal can be structured easily, and then it's all the errata at the end that get really hard.
We're often negotiating those thorny data and IP provisions, and those keep us up at night. But there's also ethical and reputational risks, and I'm wondering, do any of those keep you up at night?
Certainly. There are things that we think about it from the point of view of the biopharma industry. Our products are therapeutics, and so it's a little easier for the biopharma industry in the sense that ours are physical products. A lot of what we see from states or from the government around, or foreign countries like the EU AI Act around what they want to regulate with regard to AI, have to do with what they see coming from the products that these tech companies are offering, right? And so some of that filters down into what pharma deals with, but we are going to have to deal with it increasingly in the future. And so a couple of examples. We make, and all pharma companies make, available information about their medicines on the internet, right, to healthcare providers and to patients. So one way to think about it is, well, chatbots are useful. People use chatbots for all sorts of things, including seeking information about medicines. How do you make sure that the information that chatbots are trained on is accurate with regard to what came out of a clinical trial, out of what is part of the release packaging, as to what doctors are seeing, conferences, that sort of thing, in relation to those models being trained on social media information or other sort of information that may be accurate in some cases, may be accurate in other instances, and you don't really know. That's an information challenge that when you're the maker of a product that has safety implications, you need to think about, and you can't necessarily just do nothing, but at the same time putting out an AI-based tool might be risky too, and so solving that challenge is hard, and I don't think anybody in the industry has really solved it yet.
Putting yourself in the shoes of a biotech startup, that doesn't have an army of lawyers at their disposal, what's the one piece of advice that you would give to those companies, and especially someone at those companies that's asked to be the AI person?
With the traditional caveat that this is not legal advice, I think a holistic strategy is important. IP attorneys particularly tend to think about things in domains, right? Patents, copyright, trade secret. And those pieces are important, but it's important to be holistic about it. So if your strategy is going to be releasing open weight models to attract attention, that might be good for many reasons. It might help you recruit talent. It might help you get attention. It might get you into a pilot with a bigger company that really wants to see under the hood before they decide that they want to work with you. But it compromises the statement that the value of your company is in the secrecy or the secret sauce of whatever it is that you're doing. And so that's attention. And maybe patents play into that. Maybe they don't, depending on whether you open source. So that's one challenge. On the other hand, you could say, actually, our value is in data generation. And so the proprietariness of that data is important. And then it becomes a question as to how it's licensed. And ultimately, that's a transactionally oriented strategy. So I think it really, again, lawyerly answer, it depends on what you're trying to do, but you have to be holistic about it. And if you're trading off on one hand, you just have to acknowledge that you're trading off. Oh, I'm making this public, or I'm giving this away, and being clear about what is creating value on the other side of that.
Yeah, intentionality and deliberation around strategy is something that we constantly have to advise our clients, and particularly startups, to consider when they're making a potentially game-changing or bet the company type decision. Things that often don't seem sensible, like you said, offering the weights for free in order to get people to sign up to your service is a very different value proposition than keeping all of your data secret and proprietary in a way that prevents other people from just rote copying. But at the same time, there's no one clear path to success here, and we're not seeing any one tried and true way for companies to grow and succeed. And so it is kind of a bit of a choose your own adventure sort of situation for these companies. But at the end of the day, as long as you have a deliberate strategy around how you're going to structure your AI offerings, there's a number of paths you can take. And so I appreciate the lawyerly answer there.
All right. So final question as we near time here. I know you both are in book club. So I was wondering, what was your favorite book that you've read in the past 6 months?
I guess I'll start. Lincoln and the Bardo, which I read the audiobook, and it's narrated by Nick Offerman. And he also did, Struck by Lightning on Netflix, which I guess I'm on a Nick Offerman kick. So yeah, that's my answer.
I have to go with Dungeon Crawler Carl. It's a silly series, but oh man, is it good, by Matt Denneman. One of the lead characters is a Persian cat named Princess Donut, and I cannot get enough of it. I would read those books day in and day out if I could.
Yeah, and on vacation, I recently read or reread 100 Years of Solitude. Each time I read it, I do find something new and interesting about it, so I was glad I got to pick that up. With that, we're at time. Thank you so much, Andrew, for coming to our first podcast series. So fun to have a fellow AI nerd here, and thank you for our listeners. This is our first one. We'll have a couple others throughout the year, and we're really excited.